adhesion. All
Hey, we're
right,
live.
here we go. And this is Curt Barone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup, our holiday edition.
Hey,
And
Happy New
yeah,
Year,
happy,
everybody.
happy Hanukkah, happy everything for everybody. Okay, but Brad, go ahead. This is Fire Law Roundup for December 30th of 2024.
Yeah, and after this, for everybody watching, we're going to be next. We'll sign off, but then we're going to record the year in review, I guess, or however we call it, where Curt and I will share our top five or so cases each. Just a really quick, what we thought was a highlight. On that same token, highlighting, we're going to start in Texas here because I want to highlight some things here. This case is nothing shattering, except there are some really good don't ever do these things in this case, right? So here's what we got. So again, we're in Texas. We have a fire captain who, just to jump to the end, ultimately does get a promotion to chief, but nonetheless,
discrimination, but it wasn't all that discriminatory.
Right.
He did give you a promotion, but
he did get the promotion. But he was passed over initially, and he was passed over for a younger captain with allegedly less experience. By the way, these are all allegations, right? We say it every time. This is a lawsuit. This is not the decision. So we don't know the facts. We haven't seen a response yet. And the short of this is he claims that he was asked questions about his age and retirement, and we want to deal with those separately here. And he claimed, and how close are you to retirement, et cetera. And he claims that other candidates were asked about his age, and although notes that every candidate was asked similar questions about age, which is interesting. He doesn't get that job. And ultimately later, he was told, well, it's your age and you're too close to retirement. And so he was given allegedly some, possible reasons. He was told he had medical restrictions. So he, and it's interesting, the medical restrictions part didn't apparently work its way in here as much as you would think. But nonetheless, he's passed over, but ultimately later he's given a different promotion when somebody retires and he becomes director of, I think, ops.
He's the deputy chief. So you have your 5 bugle fire chief, your 4 bugle in this department, 4 bugle assistant chief of department, and then the deputies, the 3 bugle deputies.
I always not laugh, but I'm always, if you look at NIMS has the deputy as the second, right? You go as chief, deputy, right, then assistant.
Some departments have a 4 bugle deputy.
Yeah.
My own, I'm a 4 bugle deputy. So, I mean, different places have different ways of organizing. So,
right. Yeah. I just thought everyone would follow NIMS, but anyway, totally different issue. So that's the general lay of the land in this, but here's a couple of things. I want to go through the allegations as a learning process, right? Because otherwise this is just a harassment or a discrimination claim where they're talking about his age. Mm-hmm. Allegedly, again, I can't say that enough. Allegedly, when asked about, allegedly he was asked about his age at the interview, right? Don't ever do that. Right? Just if that's true, don't ever do that. Allegedly, not all of the applicants for the job were asked the exact same questions. You always want to ask the exact same questions and only those questions to avoid this issue. And follow-up questions should never be allowed, right? You give your answer, that's it. No follow-up.
Let me just throw it. As I was reading it, I'm like, why would you ask the age of one of your employees? You should already have that information. Why would you ask it?
Right. That's true.
Also, how close are you to retirement? You should have that information. Don't ask it.
Right. If you have mandatory retirement, maybe they don't.
Right. But I mean, that's, I think, what you're always looking at. But on the fire chief's defense here, he was brand new. I think he was the interim chief. He probably had no training. And this is one of the areas of concern here, that we have people in positions and they're doing what the people before them did, but they have no specific training on that particular area. And that's one of the reasons why I highlighted this case.
Yeah. And I think it is a big deal. And the things that also, the questions people ask never need to come off the cuff. They need to be vetted. ideally by an attorney. You should have a question bank, right? Why do they ever need the questions? Don't need to be personal in that sense. How close are you to retirement? Now, that said, I don't know if how close you to retirement is a problematic question. How old are you might be, right? Age, if you're over 40, you're protected by age discrimination statutes. But being close to retirement, to me, look, we want to hire somebody who's going to learn and grow and progress. And if you're going to retire next year, why are we going to go through all that effort just to give you a job?
Let me throw out a question that I was asked during an interview, and I do wonder whether or not it's a way around this, but it might be an acceptable way. Where do you see yourself in 10 years?
Okay.
And I think it gets around the issue, but it gets to the point that you just made.
Yep.
Am I going to promote you, and then in 6 months or a year, I've got to put somebody else here?
Right.
If somebody says, I see myself in 10 years being on a beach in Tahiti, that gives you a hint. Now, I think if you start saying, where do you see yourself in 2 years, that would be a little bit different as well.
Right. Agreed. And, and then it begs the question, why not put that just into the job qualification? Must be able to hold the job for X number of years, or must have something like that. I don't know, but asking about age, bad idea. Asking if true, asking other people about other candidates, never do that if it's true. And the question is, how did he know to put that into the complaint that other people were asked that? Did he talk to all of them? Did they say something?
He did have some conversations. And again, the complaint gets into a lot more detail than what I put there, but he did have those kinds of conversations. Yeah.
So so this type of thing, it was so easily preventable. If you didn't want to hire him, fine, you don't hire him, but don't hand him by the way, we're going to ask about your age. I mean, you're just handing somebody, please just sue us if we don't give you this job. And clearly, if it's true, it's out of ignorance, it seems, right? Because nobody intentionally would do that. It's like saying, oh, you're a black male, we're not going to hire you because, you just
well, the other famous one has to do with pregnancy. And, are you pregnant, or
do you want to have a family is the question, or right? And by the way, there are tricks that people will use on both sides, and you don't want to do it. For example, like on the pregnancy one, right, is saying, how's your family before an interview? You don't ask anything about family. You're at an interview. You're not having, right? So we don't talk about family. Or, oh, how old's your kid now? Or, oh, what grade are they in? All bad things you don't say. I even had a case, interestingly, one of the most interesting things, where they conducted interviews on a second floor. And they watched the person walk up the stairs. The elevator was off or not in existence. I don't know. And they observed how the person walked up the stairs. And the correct allegation was, you conducted a pre-employment physical exam by watching me walk up the stairs. And they were right. So you've got to be so careful with, I throw that out there because it's interesting, but you got to be so careful with interviews, right?
Yeah, there's a presumption that if you come into possession of information that it's being, and the person doesn't get the job, that is one of the factors or the factor. And this gets back to, I don't want to get too far off, but back when social media was really kind of exploding back in, 2008, 2010, in that area, and fire departments were doing social media background checks to see if people were, really behaving the way that we want our future chief or future person, and they were coming into possession of information that they can't use.
Religion, disability, age, gender, sexual preference, all of that, right?
There's a presumption that if you have access to it, that you used it, and it's, you're going to be in a world of hurt, unfortunately, like, this department is here. And they might have had a totally legitimate reason for promoting the guy that they did, but by virtue of the questions that they asked there, they've got a problem.
Yep, absolutely. Okay, let's go to Baltimore. This is a follow-up to a suit you and I have covered. This was a real quick turnaround, as suits go. I mean, where January 24th of 22 was the incident.
Yeah.
And
They
now
filed it earlier. They filed a suit earlier this year. I think it was in the spring that you and I covered it.
Yes. Yeah. Yep. So here's the short of it, summarizing this, because the holding's certainly interesting and important to employers. The incident was that firefighters got killed and injured in a house that had been condemned, or should have been condemned, and the Baltimore had not been properly inspecting and condemning the houses, and the firefighters went in and to put out a fire. There's a real short of it, right? But what the court, so they sued, saying, well, you violated your own policies and you should have, had placards and markings out to say, like the act's unsafe. And that's what the industry standard is, et cetera. And what the court does is, this is getting appealed clearly, but the court dismisses the suit. Not for the reason I would have thought is, hey, you can't sue on the job injuries, you can't sue your employer, right? You get workers' comp, and that must not have been an issue in the state. But what the judge said is, listen, in the context of employment discrimination, or employment, I'm sorry, not discrimination, too much on my mind. In context of employment, it is not enough just to state that you acted in a manner that was anything other than intentional. You intended to harm your employees. So in the employment context, right, if this had been a private citizen, it might be different. But in the employment context, the court says, trying to get rid of this case, and they do, listen, you have to allege that your employer intended to hurt you here, and you didn't. They intended to send you into the building, but not to cause injuries, death, et cetera. So they dismissed the suit because it's an employment realm type of, issue. I don't totally know why we aren't going the constitutional route, though, in this.
Oh, it is. It is. They're alleging a 14th Amendment violation, but so it is constitutional. But I guess to me, the reason this suit doesn't allege negligence or recklessness or gross negligence is that the state has immunity protection through either sovereign immunity or statutory immunity. I haven't researched all of that in Maryland, or workers' compensation exclusivity immunity. So there's a boatload of defenses that if you go under state law that you're going to have. So what many plaintiffs in a situation like this will do is they'll allege a due process violation that gets you over the hump as far as those go. But the problem here is that the case law on a deprivation of life, liberty,
right, life, liberty, property is what I'm seeing is missing here.
Well, yeah, I mean they died.
Well, no.
Deprivation of life.
I guess that's not how I'm reading the summary of this case. Is I get the 1983 part, but how is it not focusing, and maybe it is, and I'm just not getting it from summary, but how is it not focusing on their practice, not this Monell, you've maintained it, right? The Monell claim they talk about, you maintained a policy and whatever, this, you engage in a practice which deprived us of life. And here they're saying,
well, I think we got to take a step back, and the allegation, I don't, I think I have a lot of respect for the Baltimore Fire Department. They're a kick-ass fire department, and they're aggressive. They get the job done. But there's an allegation that the city had initially started this program, and for some reason in this particular part of the city, they were concerned about property values.
Yeah.
And people who might come in and buy some buildings and rehab them and invest in the community would look at the markings on the building as an indication that the building isn't worth saving. And so as a result, for ulterior motives, if you want to call it ulterior motives, the city was not marking these particular buildings. And it was not because of safety, it was because of economics. And they felt that there was a level of deception there in terms of what the city was doing. Now, that's an allegation. Whether or not they can prove it or not is an entirely different matter. But what the court here was saying is you're taking case law that developed on people being arrested by law enforcement, people being in custody, and you're applying it in an employment context. And according to according to Fourth Circuit case law, which both of the cases they cited, that, so I was just taking some notes here. Both of the cases they cited were firefighter cases. One was the Waybright case out of Frederick County, Maryland, where a firefighter in recruit training he collapsed, much like the New York case we talked about recently. He collapsed and died. And there was a question about whether or not they were pushing the recruits too hard in hot weather. So that was one of them. The other one was, I believe, I forget the name, but I think it was Wilson. It was another case out of Baltimore where a recruit was put in a very dangerous situation, and they knew that she probably shouldn't have been a firefighter. She had some different issues, but they put her in a very dangerous situation in a quiet structure. And she predictably ripped off her mask and succumbed, and she panicked. And so, but there's a question about, was that intentional? And the court, relying on those two cases, said in an employment context, it has to be intentional. And you haven't really alleged something intentional. You've kind of colored it as being intentional, but it's not really intentional. And you can't use the deliberate indifference cases of law enforcement in an employment context.
Yes, right. And the court's correct in that, except what I guess where I'm still a little confused is they're focusing on Monell, right? Monell is when a municipality has a policy, either written or unwritten, or a practice, which is tantamount to a policy, and that results in harm. And I get that. I would have been thinking that was the right claim. I keep thinking there must be another deprivation of life claim, constitutional claim that would have come into play other than Monell. I don't know. And it's not that I disagree.
Well, they did. They alleged Monell, and they also alleged a straight denial of due process. So
and I guess that's maybe where I was more
and the Monell is more about, you have a policy that deprives us of due process. Okay. And the straight due process is, you violated my due process rights by taking my life, or my husband's life, or my brother's life, or my son's life, whatever the case may be.
I'm wondering whether they could have said, listen, you violated your general duty as an employee, right? They talk about this a little.
Now you're back to a negligence. And that's what the court is essentially saying. Go back to a negligence, but there's immunity protection for that. So it sounds good, but you're basically saying, yeah, here's the door.
Except that, right. And so, but let me keep following this for a second. Is it negligence when you don't follow a policy? Right. Well, so they intentionally did not follow a policy or an OSHA regulation, let's call it. If they violate,
I'm aware of an OSHA regulation that requires marking holdings.
It'd only be safe duty. It'd only be the general.
Right. And so your general duty, sure. Yeah. It could be.
I'm stretching. Look, I don't think there should be municipal liability here for a totally different reason, which is that the city has no possible way of protecting its employees from this type of danger 100% of the time. Right? It's just not financial. It's like saying you have to place a guardrail on every dangerous highway. It's just not fiscally possible. So I take a different policy reason for this, but I don't know. I don't know that I would go on the same way the court went, but I agree with the court's holding.
I see both sides of this too. And I think for the firefighters out there that are outraged that the court would not take this into account, you have to remember that just as the city could be held liable here, the incident commander could be held liable. They could have sued the incident commander. And I don't think any of us want to see that, but then you can even take it down lower. Like, for example, the firefighters could sue the officer. In this case, the officer passed away, but you can, if you allow these types of suits, then firefighters can be suing other firefighters for these types of things that happen as well. You can't just say, oh, you can only sue the city, because once you open the door, it opens the door to all of these different types of complaints. So the idea with workers' comp exclusivity anyway is that you get workers' comp, you get your pension benefits, you get whatever the death benefit is, but you can't be suing each other for all these perceived acts of negligence.
And in Maryland, can they sue the property owner, or do we still have the the firefighters rule?
And there you go.
Because that seems to be the right suit. But it's an absentee owner, probably a phantom house. Who knows?
If you can find the perpetrators, but the perpetrators may just be, your run-of-the-mill folks that are doing this kind of vandalism. So they may be what we call judgment proof. So
yeah, exactly, and that's a real thing. Okay, so let's finish up with two quick ones. Right, first we're going to go to Georgia. This is just not funny, but funny. Not funny if you're the one who did it. The allegation is that a Georgia fire department allegedly built a new firehouse on land they didn't own. And I'm thinking about this. So just so everyone knows, if you build something on somebody else's land, you do not own it any longer. Once you build a structure on somebody else's land, especially if it's wholly contained on their land, you do not own it anymore. If you build part of your structure on somebody's land, like you cross the property line, they can force you to remove it and cut it back, even if it means demolishing. Usually what happens is you get a long-term lease with some financial benefit when it's just a couple inch or, couple foot encroachment. And I deal with that, and many attorneys deal with that all the time. Here, however, if they wholly built it on somebody else's land, they got a big problem. Not as big, however, as all of the professionals they hired in the interim. How did this get past the attorney? I'm trying to think about, now New York has a very, very, very painful, when we build firehouses, right? We have environmental analysis and all things attorneys are involved in. And I'm trying to think, like, would I have ever known if somebody came to me and said, this is my land and we're building on it? I don't know that there's a step in my process that I would even catch it. So I'm looking at the attorneys thinking, where in this process would you catch it? Now, if you had to mortgage the property, then they're going to run an abstract of title and run title down for 40 years to make sure you have title to that land. I don't know. I would probably have caught it in New York at the environmental stage, because I have to go to tax maps and see whose property it is, right? And see what type of, how it's zoned, et cetera. And that's the other thing. Zoning must have been an issue here.
Well, zoning, and I'm thinking planning as well. You've got to go meet. Now, I don't know if they're exempted from that process for somehow, right. Which that when you go for zoning, they're going to look at the site map. You've got to have the engineer maps where it's going to go, and they're going to look at it and overlay the boundaries and so on.
How do you miss it then, right? This area could not have been zoned properly to house a fire station, so they would have had to done a zoning exemption or a zoning change, I'm guessing. I don't know.
It's got to go somewhere, and then the building inspector's got to look at it again. Now, if it's on the plans as being in one location, and in reality, when it was built, it was the foundation and all the excavations on it, so I don't know. You're right. I mean, somebody at some point has got to sort of coordinate this and say, no, wait a minute. Yeah, maybe the building inspector looked at it on paper, but those stakes are not on your property. Those property, what do you call it? The foundation stakes are not on your property.
If I'm the landowner, I'm thinking, I'll sell it to you for 25% of the cost of your building, because you're going to have to pay 100% to knock it down, get it off, and then now, by the way, there is one thing which is going to save this, at least if this was in New York. 2 words: eminent domain. So the problem is, eminent domain for our viewers is where the government can seize land for a public purpose. So here they can solve this by seizing the land. However, what you pay, and I can only talk about New York's eminent domain, although I presume this is pretty true throughout the nation, you can only pay the value of the property. However,
what's the value of the property with a firehouse on it?
Yeah, I'm going to say that building is about $10 million. So you're basically buying the building from them, which they own now, right? I mean,
not just the land, it's got a building on it.
Yeah, so they'll get the ownership of the building and the land ultimately. But
what you and I are talking about right now could be why this ended up in court instead of being negotiated, because the property owner may be saying, assuming the property owner is correct,
right?
The property owner may be saying, no, it's not just $400,000 for the property. It's now $10 million because it's property with a building on it.
Exactly. So this is going to be very interesting to watch. This ultimately will be settled. I'm guessing they had to file because they preserved had to preserve some time or something. Yeah, sure. I have no idea, but
Rhode Island, we have one of the shortest statutes for property encroachments. It's 10 years. They're only at, let's see, it was built in 2018. So you're talking about, 6 years.
Right.
But,
and then the interesting thing is going to be time of discovery.
Yeah.
Right. Adverse possession, which says we told you to get off our land and you didn't.
Well, that's again, in Rhode Island, it's 10 years. Most states, it's 20 or 30 years. But
no, New York is 10 too. But
is it 10?
Yeah, but it was a change. It was a change. Nonetheless, there's a lot of ways this can go. This is going to be very interesting to see. But and then malpractice claims are going to come into this against architects, engineers, attorneys, whoever. Maybe I'm guessing. So, okay, I'm so glad this isn't about our good friend Chip. Let's go to Youngstown, Ohio. This is super interesting as a political matter, but we have the locals who are demanding that the city, their employer, reconsider its findings to stand by their fire chief. The fire chief allegedly, and maybe you got to pick up something that I'm missing here, but the fire chief allegedly had been making some racist, inappropriate comments. And yet the city allegedly said, well, this is just, the results of years of racial discrimination, meaning like it's always gone on. So it's okay if it goes on a little longer. I had to keep looking at this. Like, am I reading this wrong? Did anyone really say that? And that's in quotes.
Yeah. Yeah, I'm troubled by it. Now, I get the idea that the fire chief feels like he's under attack. I get that. Very common phenomena. And my sympathies go to the chief as far as that part of it goes. But the city can't just look the other way at this kind of comment, because if you look the other way at this kind of comment, then what happens when somebody on the other side of the political spectrum says the opposite, and now you're going to discipline that person. So this, and finding that balance is not easy. By any stretch, it's not easy. So, and the other side of this, that this is an HR issue, which is when someone is disciplined, the only people who are supposed to know about that discipline are the employer and the employee. It's not for public knowledge. So this chief may very well have been disciplined. He was suspended for a while. I think he was suspended with pay, but he was suspended. He certainly was, out of the, out of the leadership role for a brief period of time while it was being investigated. So maybe that was his penalty, and the mayor just doesn't want to, further that. But at some point, especially when you're dealing with someone that's the leader of the organization, you got to have the perception that this has been addressed. And not just ignored. And I think that's the union's point here.
And they felt that some of their allegations were not properly investigated. Right. And that again could come down to, we did investigate it. We don't have to tell you the results of our investigation, or it could come down to
addressed with the employee.
Right.
That's so.
Right. These issues become tougher and in harassment and discrimination cases, when they become hard, right? We received a complaint, we investigated it. We're not necessarily going to tell you the results. Mm-hmm. And so now you're left to wonder.
You do want to at least say it's been addressed, because otherwise it leaves it looking like nothing has happened.
Right.
So you don't have to get into the details. They had a 2-day unpaid suspension or whatever. In the Chiefs case, maybe we took away his longevity for the year, or whatever it may be. Right. But you need to at least say it's been addressed. Otherwise, it looks like you did nothing.
Right. And just so people don't say, I wouldn't do this. I wouldn't react this way in a sexual harassment claim or an inappropriate touching claim. I generally do share the results of investigations with the complainant or the victim in that case, because otherwise, you're going to face a lawsuit for not responding. Here, it's a little less severe. Not right. I'm saying we've investigated, we've addressed it, it's taken care of it. It will not happen again if it happened in the first place. But that's not enough for sexual harassment. So I don't want our viewers to think we're saying one size fits all for all of these types of complaints. But nonetheless, I think the unions stand up, straight up for not allowing or tolerating those types of comments. And I would turn to the union and say, and we expect you're going to make sure that your members don't act in any similar way. But Because I'm bothered of what's the longevity of this racist, right? And why are we acknowledging it like it's a shield versus a thorn? Right? They're saying, oh, it's gone on forever. Well, why? If it's gone on forever, they're just admitting some liability to me. I don't know. So I don't know whether that was really stated or not, because that statement of this is just a reaction to years of this. Who says that, right? Oh, our department's always been racist. Don't worry about it. And I have a hard time, so I'm just not sure what to believe in this case. Yeah. Anyway, that's it. That's it for the year.
That's it. That's it for this will be our last one for 2024. For those of you who are watching live, we're going to log off here, and we'll take us a couple of minutes here, but we will get started again with our annual review in a couple of minutes. At the end of the year, I do want to thank all of our loyal subscribers and the folks who reach out to us with comments and sometimes right on YouTube, sometimes on the blog, and sometimes by email, but we appreciate all of your support. Brad, I don't know if you saw the one somebody commented. Remember you got knocked off last
yeah. I didn't see it.
Your internet went down, and somebody commented that they're going to start a GoFundMe so you can get a reliable internet. So Brad's got a brand new house, and they're doing work out in the street in his neighborhood, and he lost the connection. So I thought that was pretty funny. But that's a loyal subscriber that wants to make sure that you got good internet connection. So
well, I know no one would want to be a minute without my opinion. So.
All right. Well, that's going to do it for another edition of Fire Law Roundup.